In Salts Healthcare Limited versus Pelican Healthcare Limited, the Court of Appeal determined a costs issue arising from the transfer of a patent infringement claim from the Intellectual Property Enterprise Court to the Patents Court. The claim was dismissed at first instance. The appeal concerned whether costs incurred during the Intellectual Property Enterprise Court phase prior to transfer were subject to that court's scale costs caps under Section 7 of Part 46 of the Civil Procedure Rules 1998. The court held that paragraph 9.2, subparagraph 1 of Practice Direction 30 provided the transferring court with a discretion to set terms, including that pre-transfer costs be assessed on the Intellectual Property Enterprise Court scale, approving Comic Enterprises Limited versus 20th Century Fox Film Corporation. As His Honour Judge Haken's transfer order had indicated that such costs should be assessed under the Intellectual Property Enterprise Court caps, the trial judge erred by not treating this as the starting point and by offering no good reason to depart from it. Re-exercising the discretion, the Court of Appeal varied the costs order to limit Pelican's recoverable pre-transfer costs to the Intellectual Property Enterprise Court scale. Quote, "The correct approach must be to apply the limits if they can possibly be applied, recognising, however, that in the end the court always has a discretion as to costs under Rule 44.3. and that includes as to the amount of costs. It is a discretion which, in my judgment, will very rarely, if ever, be exercised to exceed the limits set by Section 7. For one thing, specific exceptions are provided for under Rule 45.41, subparagraph 2. Furthermore, to exercise a discretion on a wider basis in all but the most rare and exceptional case would undermine the very object of the scale in the first place.
For a detailed summary of this decision, visit tmclegal.co.uk.